I'm Tammy Baldassi. I am doing a report for current events in my criminal law class. This week we are talking about one of the cases that we did research on was Terry versus Ohio. It's talking about search and seizure, stop and frisk, and suspicious persons and the law around that. And this particular case, the defendant stated that his Fourth Amendment rights were being violated. Anyways, I don't want to get into the whole case of the brief, but the current event that I talked about happened in Miami-Dade, Florida. The police had seized over $20,000 from a young lady and her husband on a pretty much routine traffic violation. Apparently they had cut off the police officers, what he said, and he pulled them over. The body camera shows the young lady talking about where the money came from. She was a stripper in a Miami-Dade gentlemen's club called the Cheetahs. And that's where the money came from, and that she just had not had time to deposit it. They also had found some guns that were actually registered, so but they seized that, and they also said that they saw some marijuana oil and some codeine cough syrup, and they thought that it was related to drugs, so that's why they seized the money and the guns. However, a defense attorney, Judge Francis, said that he felt that the glitter of the seize of the cash was compelling evidence to back up Ms. Brostein's claim seen on the body footage, yet about her not depositing her earnings, which was very evident in the body camera. This article came from the Newser staff from the Miami-Dade Herald. It was published on July 8th, 2018, but they went to court, and this is a current event of 2020, that the Sheriff's Department had to return the money to the young lady and her husband. They also had to pay $3,000 in court costs, that the money was seized unlawfully, that they did not have the right suspicion of persons or suspicions of any other activity or drug activity to be able to seize the information, so they had to return it back to them. We were talking about stop and frisk and search and seizure in our class, saying that you have to have suspicion enough of a person, or to have some the police has to feel in danger, or the police has been on the duty long enough to know that certain characteristics of a person may be in the process of doing a crime, may prevent a crime or prevent harm for other persons, that you cannot just stop and search someone that is a violation of the Fourth Amendment, that we are supposed to be protected of our persons, our property, our papers, and so a policeman has to have just cause to stop and search you. If you're just walking down the street and you get stopped for no apparent reason, you do have a right to question that stop, and if something was taken from you at that time, they would have to have a reasonable, if they frisk you on the outside of your clothes and they feel that it's a gun or a weapon, they can then search you farther and seize you and arrest you. However, they have to have certain cause in order to do this. Another case that I read in current event was about Homeland Security actually taking the cell phones or seizing the cell phones from protesters in Portland, and how that this was a huge violation of privacy, that they were trying to extract data from them. Say Homeland Security was trying to say that there was threats on there, on their phones, and they wanted to get this information. Mr. Murphy of the Department of Homeland Security was going in front of a committee in May. A report came out in September. However, Department of Homeland Security withheld the release of assessment threats facing the country that was furnished in March. In September, they drafted this. It was in the New York Times Dispatch about primarily convert, influence, trying to show that the phones needed to be extracted from data, that they were concerned about white supremacists and the Russians, and in infiltrating these protests. The story does not come clear whether or not they actually got the information from the phones. It just says it's a violation of their privacy, and that nobody was charged with anything, and they feel like there should be something done about being able to abstract someone's data from their cell phone if it is seized. However, in this case, it was not seized properly, so there was no warrant or anything, so they would not be able to use any of the information. Okay, thank you, and have a good week. Bye.